Good evening. Welcome to the Morrison County Board of Adjustment public hearing for September 16, 2025. Please stand for the Pledge of Allegiance. Thank you. I have a few items to cover before we get started. Please sign in at the door if you've not already done so. There you'll also find a detailed handout of the step-by-step procedure we will follow tonight if you wish to take one. Please put any electronic devices on silent mode at this time. Also, please note that all testimony is being recorded for the record. Members of the Board of Adjustment are appointed by the County Board of Commissioners with one member from each of the 5 commissioner districts. Land Services staff is here to assist the Board of Adjustments with its duties. Task of the board is to consider requests for variances and appeals from an order, requirement, or decision made by a county zoning official in accordance with the state law and county ordinance. Each request is considered on its own merit. The burden of proving a practical difficulty rests with the applicant. If a variance is granted, it is granted to the land, not to the landowner. There's a protocol for how we will proceed tonight for each variance request on the agenda. We'll hear a staff report, testimony from the applicants. The board will discuss and gather more information as needed. Next, I'll ask if there's anyone in the audience wishing to speak to this request. I will ask each party to go up to that podium, state your name and address for the record, and give your testimony. Please be as factual as possible and direct all statements and questions to me. After all testimony is complete, I'll close the public hearing portion of the process. The board will then review and discuss the case in terms of our finding of fact criteria as required by Minnesota statute and county ordinance. We'll have a series of votes, discuss whether conditions be made, and have a final motion to approve or deny the request based on those findings. After this final vote on your request, you may leave if you wish. So we do have 3 agenda items tonight, and the first one is Adam and Hannah Hebig, 1183 or 11883 North Highway 238. Please come up to the chairs here and state your name and address for the record.
Adam Hebig.
Hannah Hebig.
Okay. Ms. Amy, staff report.
Yes, Mr. Chair, this is a reconvene from the August 5th public hearing regarding this variance request to expand to a Tier 2 dairy feedlot within setback to a property line. And in particular, we're talking about the 200-foot property line on the north end of this property. Here's the property outlined in blue. And then some oblique imagery again, just to refresh your memory. And then here's some site photos taken at the property viewing back in August. So a registered Tier 1 dairy feedlot exists, and the applicant recently purchased this farm and has been managing a few issues. There was an overage in animal units. They've reduced them down to the Tier 1 numbers and have also removed animals from illegally established animal holding areas. They intend to increase the animal units to Tier 2, and that would be accomplished by adding to the current animal holding areas and expanding the existing manure pit, none of which currently meet that 200-foot setback from the north property line. The applicant is requesting a variance to expand to the feedlot, the Tier 2 feedlot numbers, and expand the existing non-conforming animal holding area and manure pit within a current kind of envelope the feedlot is operating within, and the expansions would not further encroach on that property line. The applicant would then also need to request a Tier 2 expansion conditional use permit if this variance is granted, and that's where we would get into the details of manure storage and management. So this is the updated drawing, and essentially the quote-unquote envelope of the feedlot operation is in yellow. But then there's a couple of different thresholds where that manure storage area would not be closer than 135 feet from that property line. So that would be this green line here. And then this line, I'm having trouble reading that, but let me zoom in here. It's actually a little bit more clear. So then everything else would be no closer than 4 feet from the north property line, which is right here. So that's probably a little bit clearer in your packet. But, and then here are some of the other setbacks that apply that are met. So essentially the modified ask is not for particular buildings to be a certain distance. It's just to say we want to have the ability to expand and contract within this yellow line, and with the manure storage not going any closer than 135 feet. So I hope that's clear. And then here are your criteria questions, Mr. Chair.
Thank you. Applicants, anything to add, revise to the staff report there?
Nope.
Okay. We'll open up to the board members here to discuss the application. Questions, comments?
Mr. Chair.
Clint?
Amy, so then just to clarify, within this building envelope, as long as they stay in that building envelope, meet them setbacks, then they can build in there with a building permit. They don't have to come in for each separate building other than a building permit.
Yes, as long as they're staying tier 2.
Yep. Okay.
Mr. Chair,
Marv?
I believe that's kind of where we left off before because we were beating that up, going through it. And yeah, it was a long night and got to be pretty sensitive, obviously, and it touches, home pretty hard for you guys. And I want to comment how far you came in cleaning up what was there, and you're trying to bring everything in compliance and do the right thing, and I commend you for that. And young farmers to do this and going through this, it's not easy. It's tough enough the way it is. So thank you for doing that, and thank you for trying to make this work here. So
Thank you.
I have no questions.
Mr. Chair.
Clint?
Just a comment, just so, because, we had this meeting once before and then we continued it. And just to keep in everybody's mind that there was a letter at that time on the first meeting from the neighboring property owner that said he was fine with all this as long as it was a dairy.
Yeah.
So just to reiterate what was said a month ago or whatever, so.
Okay.
Mr. Chair,
Marv?
I don't remember, did we have any conditions that were put down on this here? For some reason, I need to have that, if there were, reiterated, because I will also state a few years past, I used to rent a neighboring property, so I was familiar with it, but I knew the neighbor was okay with it. But was there any conditions or something we talked about?
Mr. Chair, I do not have anything noted that there was any discussion about any potential conditions from the last meeting.
Okay, thank you.
Yeah, Mr. Chair.
Yeah, Clint?
To my recollection, we didn't get that far, so I don't think there was any.
No, you didn't vote, so.
Mr. Chairman, so I do have a question of Adam and Hannah. So all the runoff from the yard to the east of the barns and stuff, that's all contained and ends up somewhere on site?
Yeah, as far as like the feedlot is all goes slopes to the manure pit.
Can you go up to the screen and show us?
This feedlot is all sloped this way and then sloped because there's a manure lane right in here that goes in. All this roof water goes to the manure pit as well, and then the roof water in the yard all goes to the but there's no manure runoff through any of that.
And Mr. Chair, when they come in for their conditional use permit for the Tier 2, they will have an environmental review, and that will be looked at.
Okay, very good. Thanks, Amy. Thanks, Adam and Hannah.
Yep. Okay, any other questions, comments? I should reference that there's a site visit, right?
Yes, back on August 1st.
Okay, that was this one, and then the other two were
We're last
last
Friday.
Friday, which was the 12th of September. Everybody was there? Brent? I was the only one that was not present. Brent, George, Marv, and Clint were all there. Okay. Thank you. All right, if no,
I have one more quick question.
yep.
Maybe it's for Amy. So this is a little bit different than when we're looking at buildings and given variance for. So with this type of variance, is there a time limit on this? Like we would, if we grant a variance for a building, they got 2 years. Is that different with the envelope, or how does that work?
So with a variance, you need to act on it within 2 years, and what I would consider acting on it is getting to Tier 2 status and stocking Tier 2. And so
Okay.
then that, to me, would be acting on that variance.
Okay. Just because it's a little different than the building, so.
Thank you. Okay, anybody else? Hearing none, we are going to open up this portion of the meeting to the public. Any public comment, go up and state your name and address for the record at the podium there, and feel free to speak up. Any public comment? Any public comment? Any public comment? That's the third time and final. We'll close this section of the meeting to the public, and we will move on to the finding of fact criteria and discussion questions. Okay. Question 1, is the request in harmony with the general purposes and intent of the Morrison County Land Use Ordinance and Comprehensive Plan? Clint?
I think they've worked, quite extensively with our feedlot officer in the county, and then they came in for a variance earlier, and we postponed it till now to dive into this and try and come up with a more accurate plan. And I think with eliminating, them couple buildings that were encroaching into the shoreland area, and all the work they've put into this along with staff and everything, I think it makes question 1 a lot easier to answer in the affirmative that, it is in harmony. Yes, they're still encroaching on the setback to the property line, but with the property owner, with everything else that they're doing in there, I think that kind of mitigates that. So I would have to say yes to question 1.
Thank you, Clint. Anybody else?
Yeah, Mr. Chair, I would like to make note to the north of the building is a creek there running through there, but with all the water, as Adam pointed out, running south, heading towards the pit area, nothing flowing towards the creek will mitigate any issues there. And I'm sure Clint meant that, but stating it that they're doing everything possible to contain anything so it will not do anything to have any manure, any contaminants go towards that creek area and Lowell area.
Thank you, Marv. Okay. Question 2, is the applicant proposing to use the property in a reasonable manner not permitted by the land use ordinance? I will take that one. As you've heard a couple of times, you are meeting the requests of the folks from the county here, and you put a ton of thought into this application. So from a planning perspective, as far as what reasonable means for using or using the property in a reasonable manner, with this type of planning and this type of response that you guys had, I think it's more than reasonable for what you're proposing here in the application. Anybody else? Okay, question 3. Will the issuance of the variance maintain the essential character of the locality? Marv?
Absolutely. It is, it's a farm in an ag area, and as I don't live very far from there, and they're doing everything possible. There was a lot of overgrowth, there was machinery, there were things scattered throughout. They're actually cleaning it up. It looks so much nicer now, and they put a lot of work in this. And yeah, it's starting to look like a real nice farm set now. So I commend them for that.
Thank you, Marv. Anybody else? Okay, question 4, is the alleged practical difficulty due to circumstances unique to the property? George?
Yes, I believe so. The farm was established in 1913 before land use controls were established. Riverside Dairy is located on top of a hill with the Swan River to the north, Minnesota 238 to the east, and a waterway, drainage ditch, and feed pad to the south. These unique circumstances, as well as locations of the buildings built by previous generations, really restrict the farm's ability to expand to a Tier 2 operation. So yes, it does, that it is their practical difficulty.
Thank you, George. Anybody else? Okay. Question 5, is the need for the variance created by actions other than the landowner or prior landowners? Clint?
Yes, I'd like to just reiterate what George just stated for the practical difficulty also applies to this one. And then something we haven't really talked about, or I guess we did maybe in the first meeting and we forgot to bring it up tonight, was the drainage that's to the south of the feed yard. That kind of cuts his property in half. That drainage is actually a good thing because it adds as a real good filter strip before it gets to the ditch and all them things. But the applicant's answer here was yes, the location of the river to the north and the waterways and drainage ditch to the south were previously and still are detriments to usable land on our property for feedlot purposes. Fields further to the south, getting used for cattle facilities or manure pit could easily disrupt that south waterway. And I think that was something that we probably just overlooked tonight. Just wanted to put it on the record that I think that's a huge factor in a lot of this, and it's actually probably a good factor when we look at the big picture. So I would say yes to question 5.
Thank you, Clint. Anybody else? Okay, question 6, does the alleged practical difficulty involve more than just economic considerations? Back to me. You guys answered this, I think, well in the application, how the farm site is designed to appropriately capture runoff and manure. Having to move buildings or moving current manure storage location would affect much more than just the financials, but having a negative impact on the manure management or cattle management and actual disruption of the usable farmland. There's certainly more than just the economics going into play here, especially with all the work that you've done already, time you've invested. Anybody else? Okay, we are going to move on to the vote, unless anybody has any questions or comments before we get there. Hearing none. Question 1, is the request in harmony with the general purposes and intent of the Morrison County Land Use Ordinance and Comprehensive Plan? Clint?
Yes.
John is yes. Marv?
Yes.
George?
Yes.
Question 2, is the applicant proposing to use the property in a reasonable manner not permitted by land use ordinance? John is yes. Marv?
Yes.
George?
Yes.
Clint?
Yes.
Question 3, will the issuance of the variance maintain the essential character of the locality? Marv?
Yes.
George?
Yes.
Clint?
Yes.
John is yes. Question 4, is the alleged practical difficulty due to circumstances unique to the property? George?
Yes.
Clint?
Yes.
John is yes. Marv?
Yes.
Question 5, is the need for the variance created by actions other than the landowner or prior landowners? Clint?
Yes.
John is yes. Marv?
Yes.
George?
Yes.
Question 6, does the alleged practical difficulty involve more than just economic considerations? John is yes. Marv?
Yes.
George?
Yes.
Clint?
Yes.
I got all 6 questions answered to the affirmative. Is there a motion to approve this variance as requested?
Mr. Chair, I'd like to make a motion to approve this variance.
I'll second the motion, Mr. Chairman.
Motion was made by Marvin and seconded by George to approve the variance as requested. All in favor, say aye. George?
Aye.
Marv?
Aye.
Clint?
Aye.
Aye, John is aye. Your variance is requested. Thank you for your time, and please work with the county staff to finish up everything you need to.
Yes, thank
All
you.
right, thank you. Thank you. Okay, agenda item number 2. Jeffrey Hudek and Sadie and Josh Hewitt. Have a seat and please state your name and address for the record.
Sadie Shuitt, 17335 110th Avenue, Little Falls.
Josh Schuett, 17335 110th Avenue, Little Falls.
Jeff Hodek, the same address as the previous two.
Thank you. Miss Amy with the staff report, please.
Yes, this is a variance request to establish a Tier 2 feedlot on less than 75 acres. The ordinance section is 1209.1, and that requires a minimum of 75 acres for large-scale feedlots. And then I did have Clint ask about kind of the intention of that requirement. And so here I have for you the statement of need when that original requirement went into place. So essentially, I'll just skim it. The minimum parcel sizes and greater setback requirements in the proposed amendments are intended to reduce the potential for land and water pollution and decrease the likelihood of disputes between neighbors relating to the sights, sounds, and smells of large feedlots. The expanded application process and the conditional use enforcement procedure will give parties additional information before feedlot conditional use permits are granted and provide a fair procedure with greater flexibility if conditions are violated. The rest of it really doesn't go into that. The other thing I'll add is when we did update our feedlot requirements, we did remove the reciprocal feedlot to feedlot setback. And part of the rationale was that we were still keeping the minimum parcel, the minimum acreage, and that did provide for, in the opinion of the county, enough buffering between feedlots and between properties. Here's an aerial photograph of the property. And then here are the proposed barns. And then here are a couple of photos taken at the site viewing on the 12th. So this is a 70-acre property, and it's in Section 11 of Pike Creek Township. The parcel is undeveloped and obviously in production at the moment. The parcel, the non-wetland portion of the parcel is cropped. The applicant proposes the establishment of a Tier 2 poultry feedlot on this site. The minimum acreage requirement for large-scale feedlots is 75 acres, and of course this property is 5 acres short of that. The proposed barns would meet all setbacks, and the applicant requests the variance to establish the feedlot on that 70 acres. If this variance is approved, then they will pursue the conditional use permit and details of manure management will be addressed. And here are your criteria questions, Mr. Chair.
Thank you, Miss Amy. Anything to add, revise with the report? Okay,
I guess the only thing I'd have to add is we own the property that's to the north of that. And I don't know if that was even an option, if we could have combined it to eliminate this or not.
I think that's you,
Mr. Chair,
yes.
and I'm going to ask the feedlot officer because I know we went through many, many options and talking about lots of different things, because if you recall, we did a variance on their other operation, and part of that was the long-term planning, because they were wanting to put in these chicken barns as well, and how to accommodate all of that. Colette, do you remember if there was an option to combine?
Thank you.
I can't say for 100% sure if we did talk about that, but part of me feels like when we went through the variance before with Jeff and Jared, that the home that they live in currently was gonna be combined and added to the property and the farm that they were asking for the variance on. So if they were to combine, I mean, I'm not sure how that would work, Amy. If they were to combine, they would have to go through a conditional use permit anyways to combine the proposed poultry barn to their current.
Mr. Chair?
Yeah.
Short answer, we went through so many different renditions and options. I would think that we would have come up with that, and to avoid a variance if it was possible. If you're wanting us to examine that, or if you want to just
No,
move forward with this.
No, this is fine.
Okay.
Just one thing, Mr. Chair.
It's open.
I thought that it'd have to be like,
Contiguous?
yes,
If it's just a road separating.
okay.
Because if it weren't for the road, it is contiguous, so we will consider that contiguous. But he had many different parcels and homes located and scattered across many parcels, and some of them were associated with the other feedlot. Some of them needed to be the contiguous acreage for the other feedlot, and some of them had property lines that needed to be met for the other feedlot, and you can't have it all. And that's what I have for that.
Okay.
Okay. Floor is open to the board members for questions, comments.
Mr. Chair?
Clint?
Okay, when I look at this, it meets all setbacks and all them things, but just looking at one thing, I don't know, one of you guys could probably answer, because, with corn in the field and stuff, we can't look at it, and I'm sure, if this gets passed, we'll go through the conditional use portion of it, and then a lot of these questions be answered. But my question looking at this is, to the south, there, there's some pasture or wooded or low ground that isn't gonna be a wetland or anything like that, or how low is that? Jeff, you probably can answer that one the best.
Well, actually, I can't remember the form number, but that is all farmable property.
Okay.
It's actually in corn right now, all the way up to the south woods.
Oh, okay. Then that answers that, so. Then just one more question. We didn't hear in the staff report, I don't think, about the township, but Josh kind of answered that on Friday when we were out there for the site visit. So could you kind of just state what I asked, is the township fine with the road and getting approach and all that? So you just want to go through that quickly?
Yeah, we went to the township meeting and they approved everything for the road usage that Pilgrims wanted.
And then they were, Mr. Chair?
Yeah, keep going.
And they were gonna sign a letter or something that said that it's fine to use that road even though it's not a 9-ton road.
Yep, they were gonna sign it.
Okay, so I just wanted that on the record.
Mr. Chair, I haven't been provided with anything.
But well, yeah, so we'll probably like that letter or something by the time, if this moves forward. But I just wanted that so everybody understands that.
We'll want to see that for the conditional
Yeah.
use permit, because it's a little bit more germane for that.
Okay.
So that was just something we talked about on Friday at the site visit.
Mr. Chair,
Marv?
I'd like to make a comment. As we looked earlier, why do we have ordinances? It's to protect your neighbors, protect the land, and as we have some neighbors, some individuals not being such good stewards. You look at this site and, you could see makes sense to a 70 acre, you're 5 acres shy of meeting what you need. But it meets all the purposes of the ordinances. It's that ordinance doesn't really apply to what we have here, because you have enough land around it that it should not create any other issues going forward in the future. That's just my comment.
Thank you, Marv. Anybody else? Okay. We'll be back here in a minute. At this moment in time, I'm going to open this up to the public. Any public comment, anybody wishing to speak to this application or this proposal, please go up to the podium and state your name and address for the record.
David Anderson, 11584, 170th Street. I do oppose this variance request. They have, I understand in the case of hardships and things like that, they have a 75-acre parcel just down the road. That's my comment.
Okay. Thank you. Any other public comment? Any public comment? Any public comment? Hearing none, I'm going to close this portion of the meeting to the public, and we're going to move on with any additional comments and questions. Can you pull the 75-acre property up on Beacon, please?
So, Mr. Chair, here is oh, sorry, I gotta drag this over. Okay, so here's the parcel that we're talking about now. I'm just gonna zoom out and I'm gonna put the ownership layer on. They have, there's a spot here, and I'll put the acreage on too, I guess. Let's see. There's a 75 here. They own property kind of scattered around this area, but here is
Okay. So is there, because you have a piece of property that actually meets the requirement, is there a specific reason 70 instead of the 75 that fits?
I guess one is because of the people putting the barns up Pilgrim's Pride. They wanted the barns closest to the house as possible. And when we brought this up, and I asked them where the best place to put these barns were, that was one that we thought would be the least problems.
So when you say that, and I think about Pilgrims, and I got a couple of those family members that do this, how far are those properties from each other?
Well, the 70 acres is just about touching there's just a township road in between the 70 acres and the home farm. And the 75 acres is down the road.
So a half a mile?
Yes.
Okay.
so.
I can't imagine, I mean, I don't know why Pilgrims would make that big a deal about that part of it.
And part of it was because of the 70 acres that we were putting it on was the least amount of farmland that would be. Because at the time, that 70 acres wasn't all opened.
What do you mean?
It wasn't all farmable. This year was the first year that I actually planted corn on there, so at the time of our planning this, that's where the least amount of farmland would have been lost.
Mr. Chair,
Marv?
something to point out too, the goal of the Morrison County comp plan is to protect as much ag property as possible going forward. We changed some ordinance in the last few years, and how we did it was a few different ways, and that was one of the main objectives.
Mr. Chair,
Thanks, Marv. Clint?
I could probably help Mr. Hudak answer part of this. You know, they worked with Land Services with the feedlot officer to find the best spot. That's why they come forward with the 70 acres instead of the 75. But knowing the area very well, the 75 acres that Mr. Anderson was saying that they could do, you know, that would work there also, but it's going to be a lot more intrusive to the neighborhood. I would bet, without just in my mind, they're not going to meet some setbacks to some residents on that 75 acres, where on this 70, they're going to meet all the setbacks. And then also, you look at the big wood buffer, there's 2 or 3 houses on the next road. It's a long distance, at least for odor and smell and intrusiveness for the neighborhood to put that barn there than possibly over on another piece of property, with the home farm being already used up for the other feedlot situation. So without knowing the 100% facts, my best guesstimation, they wouldn't meet setbacks on some of these other properties. So that's probably why that 70 was chosen, and that was a conglomerate decision made by you guys and Land Services and feedlot officer. So
Correct.
That helps. Thank you. Brett?
Mr. Chair, I think really what we should get back to here is, are we going to allow this to go on 70 acres instead of 75? And the rest of this will get hashed out. If it is moved forward, the rest of it will get hashed out at a planning commission meeting in the future.
Yes. And just, since I have this map up here, there isn't anything adjacent to this, Jeff, to this 70 that Mr. Hudak owns that could be combined to make up the 75. So that wasn't on the table for this particular piece.
Okay. Thank you. We had gone through this, so we're going to move on to the criteria questions. Question number 1, is the request in harmony with the general purposes and intent of the Morrison County Land Use Ordinance and Comprehensive Plan? George?
Yes, I believe it is. The request is in harmony with the general purpose intent of the land use ordinance. Area is very rural in nature, ag, some scattered residents. Proposed site meets all the setbacks. There's a lot of trees surrounding the site. Feedlot will be in the middle of a parcel.
Thank you, George. Anybody else?
Yeah, Mr. Chair. I'd just like to add that in our staff report, when Amy put the section up on kind of the reasoning why they picked 75 acres and the protections that it did, and it also protected landowners so that they wouldn't have to come for variances because they couldn't meet setbacks. This particular one meets all setbacks, so they would probably meet the setbacks with even a smaller acreage than the 70. So I think with that and looking at what the ordinance says and then the reasoning why that 75 acres in and then meeting all them setbacks and the location of it, I think that that does make it more in harmony with the general purposes.
Thank you, Clint. Okay, question number 2, is the applicant proposing to use the property in a reasonable manner not permitted by land use ordinance? Clint?
Yeah, I guess I could have probably just waited and said here, but yes, it's 75 acres. If we look through our packet, you know, if you're a tier 1, you'd only need 20 acres. You know, so part of me thinks, you know, 20 acres, you can do one barn, you should be able to do two on 40. We chose in our ordinance to go 75 to just give more protection, not only for the landowner, but also the surrounding landowners. So when we look at reasonableness, when they meet all setbacks, you look at the topograph area, where everybody lives and the residents around there, and then the predominant winds that go, it's gonna be protected from them people. So I think, you know, using this, it is very reasonable, to use this. So I would say yes to question 2.
Thank you, Clint. Anybody
Mr.
else?
Chair. Mr. Chair,
Brett?
I think I'd just add on to what Clint has said there too, but I think one other thing, when we look at the land that's required for the proposed use in ag, it's what use is that? And if you have large cattle on land would be different than having poultry barns where it's confined and indoor use with a stacking slab or whatever you have in the future there. So it's less of a footprint than large animals. So I think that makes a difference too.
Thank you, Brent. Okay, question 3. Will the issuance of the variance maintain the essential character of the locality? That one comes my direction, and as everybody has stated, you're growing corn or growing chickens on the, growing birds on that specific piece of property, zoned agriculture, with an agriculture application. And as far as the surrounding areas, it's surrounding farms. So it kind of fits within everything that already exists. Board members? Okay. Question 4, is the alleged practical difficulty due to circumstances unique to the property? Marv?
Well, as it's unique that this particular piece of property is 70 acres and 5 acres short. It would meet all the setbacks, and as what I pointed out earlier, the purpose of the ordinance is to protect the neighbors, the smells, the neighboring property, and here this will do it because it's in a remote area. And then our goal of our comp plan is to protect ag land, and this would be the least intrusive where this one is going. So there's numerous practical difficulties here. The main one not being able to meet that ordinance, but the ordinance really doesn't pertain because the other properties kind of flow with this.
Thanks, Marvin. Anybody else?
Mr. Chair, I would just state that you know, we can't use ordinance really for practical difficulty, but in this case, when you look at it, the ordinance is put in there for protection. And in this case, I think that there's enough protection without that portion of the ordinance, you know, what its effect was supposed to be meant for. I think it just don't pertain to this particular application. So I'll just kind of throw that in on that one too.
Thank you, Clint. Question 5, is the need for the variance created by actions other than the landowner or prior landowners? Brent?
The need is created by being 5 acres short of the required 75. Looks to be that there's maybe roughly 10 acres on that corner that probably was sold off years ago, so that that isn't available to this chunk of land. So the land was created and sized the way it was due to a corner chunk being sold off and having a residence built there years ago. The need for the variance is created by you can't meet the acres. So the recourse is you have to apply for a variance. And when you apply for a variance, that's for us to look at to go, is what the proposed use on that land going to be satisfied by the reduction of 5 acres? And in this case, I think it is. You got 70 acres to do poultry production there as opposed to corn or whatever else you're going to use the land for. But I think this was created by somebody else other than the landowner or prior landowners by that split that was done by that corner chunk being taken off there. That probably would have been a 80 or 85.
Thank you, Brent. Anybody else? Question 6, does the alleged practical difficulty involve more than just economic considerations? George?
Yes, I believe the applicant has tried to avoid the variance process by obtaining land or combining parcels, which seems to me to be very convoluted, but so, the acreage just wasn't available to make this a 75-acre parcel.
Thank you, George. Any finals? Okay, on to the vote. Question 1, is the request in harmony with the general purposes and intent of the Morrison County Land Use Ordinance and Comprehensive Plan? George?
Yes.
Clint?
Yes.
John is yes. Marv?
Yes.
Brent?
Yes.
Question 2, is the applicant proposing to use the property in a reasonable manner not permitted by land use ordinance? Clint?
Yes.
John is yes. Marv?
Yes.
Brent?
Yes.
George?
Yes.
Question 3, will the issuance of the variance maintain the essential character of the locality? John is yes. Marv?
Yes.
Brent?
Yes.
George?
Yes.
Clint?
Yes.
Question 4, is the alleged practical difficulty due to circumstances unique to the property? Marv?
Yes.
Brent?
Yes.
George?
Yes.
Clint?
Yes.
John is yes. Question 5, is the need for the variance created by actions other than the landowner or prior landowners? Brent?
Yes.
George?
Yes.
Clint?
Yes.
John is yes. Marv?
Yes.
Question 6, does the alleged practical difficulty involve more than just economic considerations? George?
Yes.
Clint?
Yes.
John is yes. Marv?
Yes.
Brent?
Yes.
Had all 6 of the questions answered to the affirmative. Is there a motion to approve this variance as requested?
Mr. Chair, I'll make that a motion to approve.
I'll second that.
Motion was made by Clint, seconded by Brent to approve the requested variance. All in favor say aye. Brent?
Aye.
George?
Aye.
Marv?
Aye.
Clint?
Aye.
John is aye. Your variance as requested is approved.
Thank you.
Continue to work with land services with the county, and good luck.
Thank you.
Thank you.
Okay, we are on to our third agenda item for the evening. And this is the Barbara Granquist Trust. Please come up to the chairs here and state your name and address for the record, please.
Good evening. My name is Lee Granquist, and we're talking about the address of 26458 Quail Road in Piers, which is a cabin.
Barbara Granquist,
Oh.
same address.
Okay, thank you. And this is an application for an after-the-fact variance to continue an expansion of a non-conforming deck. Ms. Amy, staff report?
Yes, Mr. Chair, it's an after-the-fact variance to keep a deck expansion and pergola within the setback to the lake. The ordinance section is 706.1 that requires a 75-foot setback. And here's an aerial photograph of the property outlined in blue. And then here's some oblique imagery. And then here is some before and after photos. And then here's a photo that was taken at the site viewing on the 12th. The The original dwelling was built in 1988 and is 64 feet from the lake. In October 2024, Land Services received a report that a deck expansion and pergola had been instructed within the setback to the lake. A first, second, and final notice of violation was sent. The applicant requests an after-the-fact variance to keep the existing deck expansion and pergola 52 feet from the lake. The applicant did not submit any stormwater or vegetation plans. And then here are your criteria questions, Mr. Chair.
Thank you, Miss Amy. Anything to add or comment, revise on that staff report?
Just that we did build the deck, as noted, and the pergola. We originally had that in our 2005 permit, but due to economic reasons and time, we did not continue on with that. So so there's no change that way, except we built it without a permit.
Thank you. I'm going to open up to board members for comments and questions.
Mr. Chair,
Brett?
I don't know who can answer this, probably Lee or Barbara. In the packet that we were provided, there were some drawings by, I'm not sure who did the drawings. I'll just show you what I'm referring to.
Yes, that is.
And I looked for a date on these because I'm kind of interested. Was this something provided now, or was this something provided during an application process in 2002, 3, 4, 5?
What you showed us was drawn in 2005, or 4, I'm sorry.
And the pergola that's on this drawing is the pergola that you built later, but didn't have a permit for it.
It is, but it's scaled back. The pergola previously included the full width of the, on the lake side of the cabin, and back towards the road and then around to the garage, which we did not put on and do not want to put that on.
Okay, I can see the part that's on the, which would be the west side, the garage side. That wasn't there when we were there on Friday. The only thing that is there is by the fireplace on the lake side, the east side.
Correct.
Yeah. Yes.
Okay. And a question back to Amy. Amy, do we know, was this in there?
That's no, that wasn't in any of the application documents. So of course, when we're looking at what was approved in the past, what was reviewed in the past, what was understood in the past, we don't have a copy of that. And I'm going to just double check, because that would be certainly something we would, and I would have included in the staff report if we had had knowledge that that was the scope of the project.
Okay, thank you. And then another question for Amy on the previous slide to our criteria questions here. If you could back up.
Yep, one moment, I'm sorry, I'm out of that here real quick. Give me just a second here.
So maybe I can go ahead and you'll understand, Lee or Barbara. On the previous slide there, it had indicated that there was a first, second, and third notice sent. And I was curious, or a first, second, and final notice, to be precise. What was the delay in responding between first, second, and final?
I do apologize. I was mistaken when we did resubmit. Can I get some dates for you?
Sure.
But we didn't resubmit for the variance. We resubmitted on March 24th for a regular permit, thinking that that would take care of it. And then I went back and forth with Darren, Willie, is that his last name? And he corrected me, and that's when this version came out.
Okay, and
So
then,
it's nothing except, it's a little late, misunderstanding.
okay, and then you went through with the DRT meeting and the variance request, and that's brought you forward till now?
Yes.
All right, thank you.
Mr. Chair?
Marv?
So you had a permit back in 2005 for this. When was this deck actually built? What year or years?
We could look it up, and we did not, but I think 2015.
Okay, so 10 years
Well,
later.
no. Okay, we'll leave it at 15
Okay.
For the deck.
for the
About
deck.
10 years. How about the pergola?
That was later, that was probably 2017.
Okay, so my question is, here, I've known numerous people that talk to land services, deal with them, and they're a pretty good staff, very good staff to deal with. Why was no one contacted on a pergola or deck, or why was they even asked, do we need here? And I did not read anything and see anything. Why was this not why didn't anybody call there?
Other than we goofed, I can't answer that. I guess we just looked at when we added on to the cabin in 2004 and 2005. That's the drawings that you were looking at. I guess I don't remember any of the county coming out for any inspections or anything like that, and I just did not go any further with that.
Okay, and so in our positions, we basically volunteer our time. We don't get hardly anything being here. And it puts us in a very uncomfortable situation, under the gun here. We're trying to decipher that, and makes their job tough too. So here we're trying to weed through this, and I'm just saying, it's not fun being on the side going through this here, and we're gonna probably look at this if we would grant you one permit now, saying, if I understand this correctly, Amy, the way we're supposed to look at this, okay, if you were to come in now to build this deck, would we allow it? That's the way we're gonna look at it.
Okay.
Okay, thank you.
I'll echo that. It puts us in a hard spot here of going through this evaluation, and then you built the deck in 2015, you built the pergola in 2017, then you pulled a permit for all of it March 24th? Did I get that right?
No, we didn't pull a permit, we applied.
You applied for a permit for stuff that was already completed.
Well, just
According to that letter.
according to, we tried to,
You see what I'm saying, right? Like, you built it, then you applied for a permit to build it.
that is correct, but we were asked by the letter saying that, that we had to take care of it, hang on, for the ordinance violation. That's the permit I applied for incorrectly.
So what is the actual impervious surface here?
It's, I think, 22%.
That's the new one with the deck,
Yes.
with the extended?
Mr. Chair,
Yes.
we were out there for the site visit. It was me, Brent, and George, and Darren. And at that time, Darren looked it up. I don't remember if it was 22 or 23, but it was stated that he is under his
Okay.
25%.
Got it.
Clint, if I could respond, the surveyor put 22%.
Okay, that's correct. That's where we looked at her. Darren got the information. Thank you.
Got it. Thank you. Board members?
Mr. Chair?
Amy?
So I'm going to drag over the 2005, I think it was 2005, and I'll just show you, there was some correspondence between the applicant and the county. Let me just pull this over. So in 2004, the application was for a house addition, a detached garage. the open-aired deck, another open-aired deck, and the height of the garage wasn't to exceed 18 feet. And then it was indicated that it would be all 65 feet from the ordinary high water mark. Then we see a letter in September that when they reviewed the site plan, that the open-aired unroofed deck and open-aired unroofed deck were included in the construction plans, but they missed it on the permit, and so they were asking to update that permit. I'm sorry. So this is in September 12th. September 7th, they were told that their permits from 2002 had expired and that they needed to apply for new permits in order to do this work. And then here's the drawing of the, existing deck. And then here is the drawing of the garage that they were applying for. Here is the new deck. However, it's noted to be open-aired here. So that was the understanding, was that all of this would be open-aired, and I'm not sure if this was...
It is open-aired. Is it, mean nothing over the top? Is that what you're saying, asking?
Yes.
Yeah, there's no pergola there, correct.
So
Where
I'm
you're
trying to
showing-
get oriented to what this is.
Posts are there.
So
Can I?
give me one moment, please. Excuse me. So in this, the review, we weren't acknowledging the pergola at all, really, in the permitting here. The understanding was it was going to be 65 feet from the lake. So there's been quite a bit of back and forth over the years with working on permits that were granted, work that wasn't done, being informed that the permits had expired and that they couldn't do work under those permits. So I'll leave this to you. If you want to see or read through any of it, let me know.
Thank you, Amy.
Mr. Chair.
Clint?
So, just maybe I'm like, not, I'm a little confused, so maybe Amy can help me with this, because, okay, so I understand you need to have the right permits to finish this work or whatever, okay,
Yep.
so I understand that. But when we look back from 2001 and 2004, when the initial work should have been done, I don't see where a variance or anything was put in here. So it basically was allowed back then. What changed that it isn't allowed now?
I don't have a great answer to that, and I'm not sure. At one point, setback averaging was allowed, and that's probably why the house was allowed to be where it is or was. At one point, you could be no closer than 50 feet. You had to be 75, no closer than 50, and you could setback average. That has gone away. And so back in 1998 or 1988, when the original home was built, that's probably why it ended up where it was. And then in the 2000s, though, the setbacks that we have now are there. However, that 15% rule was there to allow some deck without a variance within setback. So that possibly could have been why it was permitted in the first place. But there's no indication in the records as to that they were working under that or that allowance. But that is my assumption, is that's why a deck was allowed in the first place. And now, excuse me, being as though there was some deck there already, they're not entitled to any 15% rule. And then also the pergola is considered a structure which on its own would need to meet that 75-foot setback. So I'm a little hamstringed because of the lack of notes in some of this. I'm making assumptions at how we got to where we are now with what's on the property now.
Mr. Chair,
Brent?
just in follow-up with that, Amy, if someone were to come in today and had a deck and wanted to put a pergola up,
Yes,
they would need a building permit for that and meet all of those setbacks in the shoreland district.
that's correct.
And so, that's really kind of what we're looking at here is, it's kind of confusing because.
It's kind of, yeah, and Mr. Chair, it's two things. They're kind of separate animals. They just happen to be on top of each other. So the deck is considered a structure and must meet 75-foot setback, and the pergola is considered a structure and must meet the 75-foot setback.
All right, thank you.
Mr. Chair,
Yes, sir.
if I could comment on what Amy was talking about. The location of the cabin was put where she said about 65 feet. And you had a lady, same as what, lady inspector for your county. And she said we could take the average distance between our two neighbors, but not less than 50 feet. So we chose 65 feet. We should have chose 75 feet, but we chose 65. And then the other one, the 15%, was for the deck that you can come towards the lake, the 15%, which was there too. So I'm just trying to agree with her.
Mr. Chairman.
George?
So I guess where I'm really struggling on this thing is a practical difficulty. It's kind of the elephant in the room, and that's probably the hardest question we have the answer. And we have to answer that question to make this thing fly. So on question number 6, you tell us there is no practical difficulty, and that's a real problem for us.
Could you
Well,
repeat how I said that?
okay. So one of the questions that we have to answer, what the practical difficulty of this structure is, and why did you have to put it, or why did you have to build it, and we have to answer that question in the affirmative. Well, in question 6, you tell us that there is no practical difficulty, so that makes it really hard to do anything with this.
Can I come?
Yeah, go ahead.
I don't understand how did I say that?
Well, it says on question number 6, the question is, does the alleged practical difficulty involve more than just economic considerations?
I know, that's
Go ahead.
that's your question, but how did I answer it?
Okay, your question was answered, and there was no building modification or deviation from the previous permit. Therefore, there is no practical difficulty because the water runoff flow has stayed the same. But you're basically telling us there's no practical difficulty in the construction.
No, I was talking about the water runoff. I thought that the whole problem with this was the water runoff towards the lake shore. That's the practical difficulty. There is no water problems coming off to the lake. That's what I was getting at.
Okay, so,
Not what you're saying.
okay, so the house is guttered and everything, and,
No, the house has no gutters
okay,
and has never had gutters.
okay.
Marv?
Mr. Chair, so working on this practical difficulty, question 4 is alleged practical difficulty due to circumstances unique to the property. This was your response. Our deck and pergola do not come closer to the shoreline than the previous deck, so their encroachment was done. So personal need, no encroachment was done. That doesn't create a practical difficulty. I personally do not see a practical difficulty here. So I cannot answer this in affirmative as just the way you answer the questions and what we're seeing here.
quick question, when you built this in 88?
Yes.
You guys did? Okay. Board members?
Mr. Chair?
Brett?
Just maybe a comment for me. I'm a little confused on this because of the lack of maybe what's in the record from 2004 and beyond and what Roger did back then, who knows? But that said, I'm conflicted because some of the documents provided actually show the deck, show the pergola on there, and so it would be part of what your plan would be at the time. But then you take it forward again, and you were provided letters from the county back then that said that you needed to do something in furtherance, and there's no record showing that you did anything in furtherance to those requests. So I'm torn on where this thing is.
Okay, if I could respond to that?
Yes, please do.
I do remember talking to Roger, and what happened at that point is that 15% was only for the top of the deck. And we had our step out further towards the water, and that was the question he was raising, and that was what we talked about. I don't know if it makes sense, but there's one step down off the deck, and that was what he was in questioning about.
Yeah, but there was some correspondence that Amy showed from the record in 2004 or 5 where you were provided notification from the county that you would need to come in and apply, and there was no application, correct?
Not that I believe that was the 2004 application then. So what I'm able to untangle is on the left is the home, the original home with the home addition, and then with the original deck using the 15% rule. And then fast forward, then they're wanting to do the rest of this deck, and the county informs, and the detached garage, I'm assuming, and the county informs them that their permit's expired, they need to apply. So then when those come in, then they missed the deck, and that's where it kind of runs off the rails for me, is I'm not exactly sure.
Well,
What's going on
just to
there?
go on with that, if that's the record that we're looking at here,
Yes.
which it is, because that's what's before us, that deck then didn't get permitted really back then, and so the argument that you proposed to us for the after-the-fact request for this variance is we were acting in good faith off the permit that we were issued in '04, but the '04 is saying that wasn't done and that you needed to apply for the deck. And so most all of this was constructed without a permit, regardless of your statement that it was just done later.
Okay, when we applied for the permit in '04 for the 50% rule for adding on, so the house was done, and again, we had shown the deck and the pergola. It's just we did not do it. And that's what I've told you, and we did not get a permit for that. Once it expired, we did not get a re-permit for that.
Original permit in '04.
But we did have the original permit in '04. We didn't build the house without a permit, or the addition. Is that what you were asking?
Right, no, and I mean, we're really focusing on the deck and the pergola, because the pergola is the building, if you will. You have to have a building permit to do that structure on top of the open-air deck. The deck is one thing, The pergola is another issue.
Mr. Chair, I think we're beating this up bad enough, and the way we're supposed to look at this is, would we allow a deck being built today on that house? Would we allow a pergola to be built on that house?
Mr. Chair?
Amy?
I think for the first set of questions, that's the question before you. If you feel there's extenuating circumstances, if you feel that, yes, we would allow that, and you feel there's extenuating circumstances, then you could move on to your after-the-fact criteria, because that's the weighing and balancing of how did we get here, what are the nuances of that. I guess, long story short, there was no permit for the construction of what was there. We would not have permitted it. It doesn't meet setback. And so here we are. So it's not something we can just go ahead and do a late permit for over the counter because it doesn't meet setback. What the circumstances were in 2004 as to why or what rights were being extended at that point, I really can't, I can't tell you, but even if that permit had been granted, the work was done after that permit would have expired.
Thank you, Amy. Anybody else from the board here? I just have one comment for you guys to think about, and I'm going to go to public comment here, but I'm just taking some notes here in regards to some of the practical difficulty stuff, and there's we built this. This is what the average was. This is what the average was at the time of construction. This is what the equivalent of the land services director said at that time. You referenced the lack of notes or the lack of record. You've lived through probably 4 or 5 different actual sets of rule changes. But the application for what you put forward isn't the same thing that exists today. And so I'm just, nothing is lining up here for me, but as you're thinking about that, I'm going to go to the public here. So any public comment, anybody wishing to speak to this request, please go up to the microphone, state your name and address for the record and your facts for us to weigh in on our votes and decisions and considerations. That microphone right there. Thank you.
My name's Ellen McVeigh, and I am the neighbor to the west of the Granquist. We have had no problem with any of this. So if there's a rumor about, but I have a question that I don't understand as I sit in my chair. Do I understand that the deck is one structure and the pergola is another?
Yes.
Okay, I'm a nurse. Building buildings is not what I do for a living, but I've dealt with court more often than I ever wanted to. And the one question that is always asked is, what would a reasonable and sane person do in the same circumstances? And I would have never in my life imagined that a deck and a pergola were 2 separate buildings, any more than I would imagine a house and a roof were. So from the peon side of this, it's no wonder there's confusion.
Thank you. Any other public comment? Any public comment? Third and final time. Any public comment? We'll close this section of the meeting to the public.
Mr. Chair?
Well, hold on, we'll get there.
I was just going to ask Amy if she had any other neighbors call in.
I did. I was just gonna
Thank you.
say that.
Okay.
Yep, I did get a phone call from Jeff Litke. He said it looks really nice and he supports the request. And one comment from Michael Derula, and he stated that he has no grievance against his neighbor's structures.
Thank you, Amy. Okay, ready to go on to the questions? Perfect. Number 1, is the request in harmony with the general purposes and intent of the Morrison County Land Use Ordinance and Comprehensive Plan? Brent.
The only way I see this in harmony with the general purposes is that they applied for a permit back when. It's disputed now whether the county understood that they were going to put up a pergola or not. And now we're addressing this as an after-the-fact variance request, and they are entitled to request a variance. And so in that regard, I think it's in harmony with the general purposes.
Thank you, Brent. Anybody else?
Mr. Chair,
Clint.
I would just add that when we were out there for the site visit and looked around the yard and the way the lake shore was bermed up and no water runs to the lake, if we look at why we look at some of these things is to protect the water, protect the lake shore and all them things, there was absolutely no sign of erosion on this property. The water was taken care of as far as going into the ground. There wasn't a huge slope to the lake. So I think that's part of it that we want to look at is also on this is, is there a lot of water getting to the lake? Is there some contamination? Is there some erosion? And on that site visit, I saw none of that.
Thank you, Clint. Anybody else? Question 2, is the applicant proposing to use the property in a reasonable manner not permitted by land use ordinance? George.
Well, I guess, yeah, the request would be reasonable. His impervious surface is always a huge item for us, is 22%. Is the deck reasonable for the house? It looks good on the house. It fits in the neighborhood. So I would say yes, that it is reasonable, comparing it to the neighboring residences.
Thank you, George.
Mr. Chair?
Marv.
I'd like to add also, it is reasonable to have a deck out in front of the lake and enjoy the lake property. I think most of them want that and would like that, so it's a reasonable ask.
Mr. Chair,
Thank you, Marv. Amy.
I just want to interrupt because we're talking about the deck. We also need to be, so are you answering for the pergola as well? I just want to make sure that that is addressed.
Yes.
Okay.
I missed that, but yes.
Okay. Marv, good?
Yes, I am. I agree with that. I was hoping they would be considered as a whole, but as it was brought up, they're two separate pieces.
Thank you. Question 3, will the issuance of the variance maintain the essential character of the locality? Clint.
When you look on that shoreline there, I talked about how the shoreline was in pretty good shape and that type of thing. But then when we look at the essential character of the structure itself, so when we talk about the house, I think the house fits in very nicely with surrounding houses there. And then you look at the lake view and looking at that house, it kind of fits in very nice. And then when we look at the deck, it's not as close to the water as some other ones. Another thing that I'd point out is that deck, if we can argue if it's too big, whatever, but it's barely a step up, so it's kind of ground level, it's not as noticeable. The pergola is a lot more noticeable, but if you're on the lake side and you're driving by, the way the house is designed, it's not like it jumps out and sticks out at you, and it's like something that somebody's going to really notice. Not saying that we're looking at issues here if it should be allowed or not, but when we look at it from like a aesthetic portion of it, I don't think it's going to be a hindrance. And then when you look at the other cabins on that side of the lake, there's some pretty nice ones right there, and it kind of fits in right with them. So I would have to say yes to that question 3.
Thank you, Clint. Anybody else? Question 4, is the alleged practical difficulty due to circumstances unique to the property? And I'll take that one. I started going through your answer to the question, which was our deck and pergola do not come closer to the shoreline than a previous deck, so no encroachment was done. That is true, even if you were doing something on the opposite side of your property on the house, on the detached, because of where your building is located, any and everything that you do is going to require some sort of new ask or variance in it. So, but yes, you're correct. The previous deck is there. The thing that I'm having a hard time with is it's just the lack of record that Amy had noted here, the application response. But again, you go back to this whole thing. Would we look at this and say, yes, this is reasonable, and you're able to do it prior to and after the fact event? And I think that's where your practical difficulty of starting construction in 1988 and living through 4 or 5 rule changes up to this point. You can't do anything on that property now because of where you originally built it and what was allowed at that time.
Mr. Chair?
Marv?
I want to point out personal want, personal need is not considered a practical difficulty because of the deck, the way you want it, the way the pergola, the way you want it placed and everything is not a practical difficulty because it's more of a personal want.
Thanks, Marv. Good. Question 5, is the need for the variance created by actions other than the landowner or prior landowners? Marv?
Well, I think the need for the variance probably was, it was the placement of the house like that, and it was the previous landowner. And then also the way the deck was placed is created by the landowner now. So I believe this variance is created by the previous owner and you now.
Amy?
You built this house, right? We built it.
Yep, we're getting there.
Okay, if that's the case, then it was created by you.
I just add, Mr. Chair,
Clint?
just going to add, and this is where we're trying to look at this as today, if he's asking for this, but then we're also looking at something that's built here. And I would say part of this problem is not, I agree with Marv on most of it, but it's also that it was this whole permitting thing, part of it's just you timed out, you didn't do that process right, so, that's on you, but then it's also on, other factors than just that. It's the lack of knowing exactly what's going on. We can't account for all this. So, yeah, part of it is on you, but I'm not going to say it is all on the landowner. That's all I'd like to say.
Mr. Chair?
Marv?
So it is the landowner's responsibility as laws and regulations continue to change. As you heard my comment earlier, was why didn't you call land services? Why didn't you make these calls? Why? And we hear contractors saying it's okay to do this, and people do it. And then after the fact, they come in there and they say, "Well, my contractor said that." Then we got to hear these. You had the opportunity, and it's on you. I'm sorry. I'm sitting here. I don't want to be here for that reason, but we have to decipher this whole thing, and that's why I said, this was your mistake. You know you made a mistake, and it sucks, but we have to fess up to it. And I've made too many mistakes in my life, and I wish I could turn back some of this, but life goes on.
Thank you, Marv. Anybody else? Number 5. Question 6, does the alleged practical difficulty involve more than just economic considerations? Brent?
I'm struggling with the practical difficulty here. Based upon the record that's been presented to us, it reflects that it wasn't permitted. The pergola wasn't permitted. There is some indication in the record that it needed to be addressed and permitted back then. That wasn't done. The understanding and testimony that we heard tonight was that they thought they had a permit and went ahead and built it, even though it would have, if it was a permit, it was expired, and went ahead and did it. So I'm struggling with the practical difficulty here. I'll just leave it at that.
Thank you, Brent. Clint?
Mr. Chair. Just look at something that the homeowner stated, you know, he was permitted at one time to do all this, and then he stated that he didn't do it at that timely fashion because couldn't afford it all. You're gonna do it later on. So that's just something to think about on question 6.
Thank you, Clint. Anybody else? That wraps up our questions. Moving on to the vote. So question 1, is the request in harmony with the general purposes and intent of the Morrison County Land Use Ordinance and Comprehensive Plan? Brent?
I'll say yes.
George?
Yes.
Clint?
Yes.
John is yes. Marv?
Yes.
Question 2, is the applicant proposing to use the property in a reasonable manner not permitted by land use ordinance? George?
Yes.
Clint?
Yes.
John is yes. Marv?
Yes.
Brent?
Yes.
Question 3, will the issuance of the variance maintain the essential character of the locality? Clint?
Yes.
John is yes. Marv?
Yes.
Brent?
Yes.
George?
Yes.
Question 4, is the alleged practical difficulty due to circumstances unique to the property? John is yes. Marv?
No.
Brent?
I'm gonna have to say no.
George?
No.
Clint?
Yes.
Question 5, is the need for the variance created by actions other than the landowner or prior landowners? Marv?
No.
Brent?
I'm gonna have to say no here as well.
George?
No.
Clint?
Yes.
John is no. Question 6, does the alleged practical difficulty involve more than just economic considerations? Brent?
No again.
George?
No.
Clint?
No.
John is yes. Marv?
Yes.
I do not have all of the questions answered to the affirmative. Is there a motion to deny the variance as requested?
Mr. Chairman, I'll make a motion to deny the variance as requested.
Okay, is there a second?
I'll second that.
Motion was made by George and seconded by Marv to deny the requested variance. All in favor say aye. Brent?
Aye.
George?
Aye.
Marv? Clint?
Aye.
John is aye. At this time, your variance for the application has been denied. Please continue to work with Land Services as you move forward.
So our next step is work with them?
Yes, sir. Thank you. We are on to the new and/or old business on the agenda.
Mr. Chair, I don't believe I have any old or, I don't have any old or new.
Okay. September 2 minutes. Any edits, revisions from the board members here?
Mr. Chair, I make a motion to approve the minutes.
I'll second that.
All in favor?
Aye.
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 Aye. Minutes approved from September 2nd. And one final item.
Mr. Chair, I make a motion to adjourn.
I'll second that.
All in favor?
Aye.
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 Aye. Meeting adjourned at 8:17 p.m.